An overview of the law on medical assistance in dying in Canada. My name is Jocelyn Downie, and I'm a professor in the Faculties of Law and Medicine at Dalhousie University in Halifax, Nova Scotia, Canada. I'm going to walk you through the key components of Canadian MAID law. So we're going to cover the eligibility criteria, the procedural safeguards, advance requests, independent and parliamentary reviews. So first, what is MAID? Well, it's the administering of a substance to a person at their request that causes their death. Or it is the prescribing or providing of a substance to a person at their request so that they may self-administer the substance, and in doing so cause their own death. In other words, we have two types. We have provider-administered and self-administered MAID. Well, who can provide MAID? In Canada, unique in the world, physicians and nurse practitioners can provide MAID. Who can access MAID? Well, you have to be eligible for government-funded health services, be at least 18 years of age, be capable of making decisions with respect to your health, have made a voluntary request for MAID, which is not made as a result of any kind of external pressure, and have given informed consent to receive MAID after having been informed of the means available to relieve your suffering, including palliative care. In order to access MAID, though, a person must also have a grievous and irremediable medical condition. This means you must have a serious and incurable illness, disease, or disability, be in an advanced state of irreversible decline in capability, and have an illness, disease, or disability, or be in a state of decline that causes enduring physical or psychological suffering that is intolerable to the person and cannot be relieved under conditions that they consider acceptable. Now, it's very important to note that until March 2023, mental illness is not considered to be an illness, disease, or disability for the purposes of the definition of grievous and irremediable medical condition. However, this exclusion will be automatically repealed in March of 2023. So this means that you can be eligible and have a mental illness as long as you also have another serious and incurable physical condition. It means that you cannot be eligible for MAID where mental illness is the sole underlying medical condition until March of 2023, at which point what we call MDS-UMC will be legal. So let's turn now to the procedural safeguards. There are two sets of procedural safeguards, and which ones you have to follow depends on which track you are on. We have two tracks. Track one is for persons whose natural death has become reasonably foreseeable, and track two is for persons whose natural death is not yet reasonably foreseeable. Now, obviously, there's a very critical expression operating here, which is natural death has become reasonably foreseeable. It's critical because it determines which procedural safeguards track you are on. So it's very important to know that natural death has become reasonably foreseeable, NDRF, does not mean you have to have a prognosis of 12 months survival or 24 months, or indeed any specific temporal prognosis. NDRF does mean one of two things: that you have sufficient temporal proximity, and that can be a matter of years, many years actually, and or you are on a predictable trajectory toward death with no prognosis having been drawn. So for example, on diagnosis with ALS, a lethal neurodegenerative condition, you would meet NDRF. Now, you won't meet the other criteria on the day of diagnosis with ALS, but you would meet NDRF because you are on a predictable trajectory toward death. Okay, so what are the procedural safeguards? For both tracks 1 and 2, here's the set. You have to have 2 medical or nurse practitioners be of the opinion that the person meets the eligibility criteria. The request for MAID has to be signed and dated before 1 independent witness. The person has to give informed consent to receive MAID after having been informed of the means that are available to relieve their suffering, expressly including palliative care. And immediately before providing MAID, the person has to be given an opportunity to withdraw their request, and the physician or nurse practitioner ensures that the person gives express consent to MAID. Now, there are 2 exceptions, advance consent and a waiver of final consent, and I'll tell you a bit more about those in a few minutes. So those are the procedural safeguards for both tracks. There are some additional procedural safeguards that are unique to track 2. So a reminder, that's when natural death has not become reasonably foreseeable. First, if neither the first or second physician or nurse practitioner has expertise in the condition causing the person's suffering, the first or the second practitioner has to consult with a physician or nurse practitioner with that expertise and share the results of the consultation with the other practitioner involved. The person suffering has to have been informed of the means available to relieve their suffering, including where appropriate counseling services, mental health and disability support services, community services, and, as with track 1, palliative care. The person has to have been offered consultations with relevant professionals who provide counseling services, mental health and disability support services, community services, and palliative care. Also, both of the physicians and nurse practitioners have to have discussed with the person the reasonable and available means to relieve the person's suffering and agree with the person that the person has given serious consideration to those means. Also, there have to be 90 clear days between the day on which the first assessment begins and the day MAID is provided. That is, unless the assessments have been completed and both the physician and nurse practitioners are of the opinion that loss of capacity is imminent, in which case the period can be shorter, whatever length the provider considers to be appropriate. Also, immediately prior to providing MAID, the person must be given an opportunity to withdraw their request, and the physician and nurse practitioner ensures the person gives express consent to MAID. Now, there are two important exceptions to the requirement of final express consent. The first is called final consent waiver. It is for those who have been assessed and approved as eligible for MAID. This only applies to track 1 people. So you must meet the eligibility criteria for MAID. Natural death has to have become reasonably foreseeable. You have to be at risk of losing capacity to consent to MAID. And if these conditions are met, you can come to a written arrangement between the patient and the provider for MAID to be provided on a specified day. And then the person consents in a written arrangement to the provision of MAID if they lose capacity prior to that day. And then they can have MAID on or before that day. And MAID can only be provided if the person does not demonstrate resistance or refusal. And I star refusal because that's explained a little bit in the legislation where it says involuntary words, sounds, gestures made in response to contact do not constitute refusal or resistance. Now, the second kind of permissible advance request is called advance consent. It is for failed self-administration, and it is available for persons on both tracks 1 and 2. To access this exception, you have to meet the eligibility criteria for MAID, and then you come to a written arrangement that the provider will be present at the time the person self-administers and administer the meds to cause the person's death if, after self-administering, the person lost capacity to consent to receiving MAID and didn't die within a specified period. So that's the eligibility criteria and the procedural safeguards for MAID in Canada at the moment. There are 2 review processes to watch, and I just want to tell you a little bit about them. They are the independent review and parliamentary review. So first, the independent expert review. This is an independent expert panel that will be mandated to recommend protocols, guidance, and safeguards to apply to requests for MAID by persons with mental illness. Their report, which will contain conclusions and recommendations, must be provided to the ministers no later than March 17th, 2022. And the ministers must then cause the report to be tabled in each houses of parliament, so the House and the Senate, within the first 15 days on which the House is sitting after the day on which they receive the report. So this will likely be spring of 2022. Now, it's important to note that this review is about how, not whether, to permit MAID for persons with mental illness. MAID for persons with mental illness as their sole underlying condition will be legal as of March 2023. So this panel is designed to advise about implementation. The second review, on the other hand, may lead to changes to Canada's MAID law. This is a parliamentary review, and its mandate is to review the Criminal Code MAID provisions and their application, including but not limited to the following issues. Mature minors, these are individuals who are under the age of majority, but who have decision-making capacity. Advance requests outside the narrow parameters of the two exceptions that I explained, the final consent waiver and the advance consent for failed self-administration. So for instance, advance requests were made before diagnosis or before the onset of intolerable suffering. They're also going to look at mental illness. They're going to look at the state of palliative care in Canada, and they're going to look at the state of the protection of Canadians with disabilities. Now, this parliamentary review will be conducted by a joint House and Senate committee. It's supposed to commence review by April 2021, and it is supposed to submit its report no later than April 2022. So that is the state of MAID law in Canada as of April 2021. For more and continually updated information, you can go to eol.law.dal.ca.